Welcome everyone to Landmark Chamber's webinar on state aid and subsidy control post-Brexit, an update. We're really pleased to see so many of you joining the session today, and we hope you'll find it useful and informative. I'm Buley QC. I'm a barrister specialising in public and regulatory law, and I'll be chairing the session today and also speaking in the first session. And I'm going to be joined by my colleagues James Neill and Luke Wilcox, who I'll introduce to you in just a moment. I'll do that at the start before we get going, so that we don't have any interruptions during the sessions. Just a few housekeeping points then before we get to that. First of all, your microphones will have been automatically muted, and so you don't need to adjust your settings or your local settings. We very much welcome questions throughout the sessions, but we ask that you submit them via the text in the Q&A section of the screen, and I think that depending on your setup, that'll be at the top or bottom of your screen. We'll do our best to answer those questions as fully as we can at the end of the presentations, and in the event that we're not able to do so, what we've done in the past and I'm anticipating we'll want to do here is try and provide some supplemental written answers if we can later on. We'll have to see how time plays out, just to see how many we can answer. The webinar is being recorded. I hope that's, and you'll receive a link to the presentation and the recording shortly after it concludes. If your connection is lost at any point during the webinar, we just ask you to rejoin the meeting. You should be able to do so on the original link. Okay, so with all of that said, let me deal with introductions. As I said, I'm Buley. That was a photo taken before lockdown and a small baby arrived and I was looking a bit more chirpy. But I'm going to be joined by, I'll do it in the order that they're going to be speaking. So Luke Wilcox, who is a specialist in all issues, any and all issues relating to land law. He practices across the fields of planning, rating, where he's acknowledged by the directories as a leading junior, one of the leading juniors in the country, I should say, in property law. And relevant to us, he regularly advises and represents both companies and local authorities in public law disputes with a land element, and has recently advised on a number of clients on the interaction of state aid law, in particular with business rates relief. And Luke's going to be speaking first about the important topic of the Trade and Cooperation Agreement, the contents of that agreement. And then we'll be going to James Neill as the last speaker, last but not least. James is the head of Landmark Chamber's Procurement and State Aid Group, and he has really very considerable experience in high value procurement litigation in both the administrative and TNC courts. He regularly advises UK public bodies and contracting entities also in relation to state aid, risk arising from major development and infrastructure projects. Now, James is going to be speaking about the highly important and new topic of the Subsidy Control Bill, which of course was only published 2 days ago. We obviously planned this session brilliantly, knowing through our crystal ball that the bill would be published 2 days before. So we hope that's worked out quite well, but there may have been some luck involved. James is going to be talking to you about that. I spent the last 2 days in the Court of Appeal, or preparing for and being in the Court of Appeal, so I haven't really had a chance to look at the bill. So I'm very much looking forward to his explanation of how it's all looking. So that's the programme to come. But as I say, I'm going to be speaking first, and what I'm going to be trying to deal with is the vexed and I think genuinely rather difficult, but also rather interesting issue of what the current position of state aid, or as we now call it, subsidy control law, is in the UK. State aid, of course, is the term that's been used previously prior to Brexit, but subsidy control has become the new jargon. Whether that makes a real difference or whether that reflects just a kind of change in fashion and a desire to differentiate, for the UK to differentiate itself from the EU, I'm not quite so sure. Anyway, that's going to be my topic. What is the state of state aid law at the moment, pending, of course, the new legislation, which will hopefully make things much clearer. And on that issue, the position isn't very clear. So the context for what I want to be talking about is the obvious point that we've now left the EU and left the implementation or transition period. UK no longer subject to the EU treaties, but has signed up to these separate treaties, the withdrawal agreement, which is critical for state aid in Northern Ireland, although I'm not going to be speaking about that because that's a whole other topic, and now the trade and cooperation agreement at the end of last year. Now, state aid law, as it was then called, was previously derived from EU law, Articles 107 and 108 of the Treaty of the Functioning of the European Union, almost exclusively, and that was given effect prior to Brexit via the European Communities Act 1972. But that's been repealed. So where does that leave us? What is the current position for state aid law after Brexit? And I'm going to be talking about that issue under 3 different heads, which we'll come to in a moment. I'm not going to be covering the contents of the Trade and Cooperation Agreement, which Luke is going to be talking about in his session, but I will say something about the rather important topic of what its legal status for the time being is, as opposed to going forwards once we have new legislation. Okay, so first heading then, EU state aid law and its repeal. And for those of you who were able to attend the session we gave about a month ago on procurement law, some of this will be familiar. I'm going to take it slightly more quickly in terms of the kind of legal underpinnings of the Withdrawal Act than I did when I looked at the procurement position, partly because I know that some of you will have attended those sessions, and partly because the focus is a bit different now for reasons we'll see. Because whereas in procurement law, what we've effectively done is retain EU law with a few relatively minor tweaks. I mean, it may be bigger tweaks going forward, but for the time being, procurement law remains broadly looking like it did before. In relation to state aid, the position is quite radically different. So the position is that the EU Withdrawal Act 2018 repeals the 1972 Act, but then goes on to provide seamlessly for the retention of most pre-existing EU law, and which is then thereafter known as retained EU law, through sections 2, 3 and 4. And for the purpose of state aid law, the relevant section is section 4, because that preserves, among other things, EU law derived from the EU treaties, the directly effective provisions of the treaties, and as I've just said, that therefore includes Articles 107 and 8 of the TFEU, which are the basis for or are the basis for state aid law in the EU, and were therefore the basis for state aid law in the UK. Now then, importantly, that preservation of retained EU law is itself subject to, maybe subject to is not the right word in a way that I'll explain in a moment, but potentially subject to section 8 of the 2018 Act, which gives the ministers the power to amend retained EU law. And what section 8 does is it does provide this power to amend retained EU law, but are on the face of it, although it's a very broad power in some ways, nevertheless limited purposes. And so under subsection 1, the power is to do so in order to prevent, remedy or mitigate, and then the statutory wording continues, any failure of retained EU law to operate effectively, or any other deficiency in retained EU law arising from the withdrawal of the UK from the EU. So there's quite an important set of limitations there. You've got to be preventing, remedying or mitigating, first of all, not avoiding, but preventing, remedying or mitigating a failure of EU law to operate effectively, or any other deficiency. And deficiencies are in turn exhaustively defined in subsection 2, which I haven't set out and won't go through now, but they include notably things like, and this is in some ways the classic example, areas where previously retained EU law would have referred to say an EU institution, and that EU institution would have no role in the UK after Brexit. So in the procurement context, for those of you who recall the session last time, one of the things that was done with the procurement regs was simply to or the public contracts regs was to change references to the Commission to references to an EU body and get rid of references to the official journal of the EU. Any sort of minor tinkering is done, in other words, under section 8 there. And the thought that this is not necessarily a limited power, but that it's a power with limits is reinforced by statements that were made to Parliament and recorded in Hansard about the use of section 8. In particular, that section 8 was not to be used to make major, or any indeed, policy changes to EU law. It was there in order to provide for these sort of efficacy type amendments to make it work properly in accordance with the policy that it previously had. Major policy changes are of course possible, but they're to come forward via primary legislation. So much for that then. So what's been done in relation to state aid law? Well, the government originally proposed to retain state aid law, and it published in 2019 draft regulations under Section 8, which were never given final effect. And they did very much the sort of things for state aid law, which was done for procurement law. So, for example, and most importantly, they transferred responsibilities of the EU Commission to the Competition and Markets Authority. That looks, again, and just as we had in procurement context, that looks like the paradigm example of the use of the Section 8 power to address problems and incoherencies in EU law which would arise from withdrawal. So much for that, because then in the sort of closing stages of the negotiations, and possibly, who knows, but possibly as a sort of bargaining thing as much as anything else, the UK decided it's going to do something quite different. And the 2019 draft regulations were replaced with draft and then final state aid revocations and amendments EU exit regulations 2020. And the effectively the 2020 regs is quite simple. It repeals state aid law. So that all of that body of what would have been retained EU state aid law under the Withdrawal Act, by virtue of the Withdrawal Act, is simply gotten rid of and has no effect in UK law from the time of final exit. Well, sorry, it's not the exit day. I should have said it's from the end of the implementation period, the end of last year. I'm sorry, that should say 2020, not 2021. So that's what's been done. So EU retained EU state aid law. On the face of it, doesn't look like it has any ongoing existence. But there is a real issue at any rate, and this is why I've gone through in this a little more detail than might be otherwise have been thought justified by the fact that it's all been abolished, about whether the 2020 regs are lawful. And the reason for that is, it comes back to what I've already said. They were made under Section 8 of the 2020 Act. They don't, and they do not appear to simply, and I'm referring back now to the statutory wording Section 8 that I gave you a moment ago, they don't appear simply to prevent, remedy or mitigate the deficiencies in state aid law arising from withdrawal in the way that was done, for example, in procurement law, or which was done by the 2019 regulations. And they don't preserve the underlying policy of state aid law as it previously existed whilst making it workable. They simply abolish it. On the face of it, they make a major policy change, in other words, the very thing that Parliament was told couldn't be done under Section 8 and simply on its language, strongly arguably can't be done. So that would be the argument that those regulations are unlawful, in which case EU state aid law perhaps has some ongoing legal consequences in the UK. Now, the Good Law Project, and I acted for them in the challenge, which is why I know about it, brought a challenge to the 2020 regulations, effectively saying that they were unlawful for those reasons. And the Good Law Project's interest in it was, in part, of course, to ensure legal certainty relating to state aid, but in part it was a sort of wider constitutional issue about the limits of Section 8 and the government was using its power. And that being so, and one might think regrettably, certainly from the perspective of doing an interesting case, regrettably, the GLP then decided to withdraw the claim because the government announced that it would make primary legislation in relatively short order. And the GLP felt that in those circumstances, their interest in the matter was reduced and they decided not to proceed with the challenge. So the interesting question which I've highlighted as to whether the 2020 regs and therefore the abolition of state aid law is lawful remains unresolved for now. Now, does that mean that the point goes away? Well, it might do in practice because of the time limits for challenging delegated legislation. Obviously, most of you will know that the time limits for challenging by judicial review any public law act, and that includes the making of delegated legislation, is 3 months. That time limit expired on any view by the end of March 2021, perhaps a little before because the regulations were made slightly earlier but didn't come into effect until the end of the last year. So on one view, that's an end of the time for challenge, and even if there is a strong argument the regulations are unlawful, that's an end of the matter, but it's not necessarily so. As I have good reason to know from arguing about these issues in a different context yesterday in the Court of Appeal, there are different ways in which delegated legislation can be challenged, and a recent case is very useful on this, and I've cited it, nothing to do with state aid. It's the Badmus case, which makes clear that on the one hand, if you want to challenge what's described as an abstract challenge to delegated legislation, you do indeed need to bring your claim within 3 months. But you can, if you're a person affected by the legislation, bring it within 3 months of its effect on you. And there's also the possibility of collateral challenge. So you may be able to raise it, for example, as a defence in another form of litigation. Now, none of those things are completely straightforward to apply here, because it's not clear how the 2020 regs can be said to apply to an individual or to a firm once at a later date than the date on which they would abolish the legislation. But there may be scope for argument about that, and therefore the issue, I think, is not necessarily completely dead. It'd be interesting to think about scenarios in which that could be brought forward. Anyway, that's the position on, therefore, EU state aid law. It is abolished, but there is a genuine issue about its legality, the legality of that abolition, which could conceivably nevertheless rear its head in future cases. Where does that leave us then? Well, on the face of it, it leaves us with no body of proper state aid or subsidy control law, but of course with a series of obligations, international obligations, including under the TCA. So let me turn to that now. Now, as I say, Luke is going to be talking about the content of the TCA, and I don't need to say anything about that, but I just want to touch about what I want to deal with in this section is what its legal consequences for the time being are in domestic law. Because of course the TCA is an international legal agreement on the one hand, whereas the UK is, as many of you will know, is a dualist country. What that means is simply that international law obligations that the UK has entered into don't take automatic effect in domestic law. They have to be implemented. That's why, for the purpose of EU law, we had to implement our EU obligations, for example, under the European Communities Act. Some of the international obligations we subsequently entered into with the EU, for example, the withdrawal agreement, are implemented directly by the 2018 Act. What then is the position in relation to the TCA? Well, Parliament has made very hurried, for the time being, implementing legislation for the TCA, but it did so by way of the EU Future Relationship Act 2020. In some respects, the FRA, I'll call it, makes detailed, relatively anyway, detailed provision for implementing the TCA. So if you look, for example, at the provisions relating to security, some of the provisions relating to criminal matters, that's given quite a detailed implementation in particular sections of the 2020 Act. But not so in relation to many other parts, including subsidy control, where we have to fall back on sections 29 and 31. Now, section 31 is a very broad power to make delegated legislation, but that hasn't been exercised in relation to subsidy control, so don't need to say anything more about that. That leaves us with section 29. And section 29 says as follows: existing domestic law has effect on and after the relevant day, and the relevant day is when we left, or sorry, it's the end of the implementation period, with such modifications as are required for the purposes of implementing in that law the TCA, so far as the agreement is not otherwise implemented, etc. I won't read out the rest. Two critical points there. First of all, it takes effect in relation to existing domestic law. And the reason that's important is it does look like you might need to identify some pre-existing relevant domestic law, or at least it's not clear how the thing works if you don't. And as I've just said, since EU state aid law would certainly be relevant if it remained part of our law, has been abolished, we don't have an obvious body of domestic law. We may have very specialist bits. So, for example, you might start to look at local authority best value obligations in relation to land, but they're very specific to particular contexts. And then, so far as implementation is necessary. What does that mean then for the TCA? Well, oops, sorry, I think I've slipped on too many slides. Here we go. Well, Luke, as I say, is going to be talking about the detail of the TCA, but I just want to note a general feature of the way that the subsidy control provision works, and you can see it in Article 366, for example, because what it does is not, as we used to have just via not only Articles 107 and 8 of the TFEU, but also by the very extensive case law the CJEU developed, not set out a detailed code, as it were, in relation to state aid. but simply provide for the obligations of the parties, including the UK, to have a system of subsidy control. So the basic obligation in Article 366, which I think is probably the most general one, but you'll see other examples of it, is that each party shall have in place and maintain an effective system of subsidy control that ensures that the granting of a subsidy respects the following principles, and then various principles are set out, which Luke will perhaps touch on. But they're very broad parameters. It's a framework for the kind of state aid law which we're required to have, as opposed to a detailed code providing for what that framework is. And in those circumstances, it is not obvious, to put it mildly, how the courts can simply pick up the TCA and give effect to it in UK law in any meaningful way. Because, as I've said, there is no pre-existing body of state aid law at the moment, that's subject to the very particular areas like best interest for local authority and so forth. And you can't then take that pre-existing body of state aid law and say, well, okay, in order to comply with our obligations on the TCA, you need to limit this, or you need to change that, or you need to, you know, you need to impose a threshold of this such and such amount, or whatever. Because the obligations, as we'll see in a moment, the obligations under the TCA include things like having a court system, having an independent body. Well, the court can't just invent a public body to oversee state aid law. It can't, it's not at all obvious how it can give effect to those principles directly. And so the combination of the fact that on the one hand you don't have a pre-existing body of state aid law, and on the other hand that you don't, that the TCA itself only sets out very general principles, makes it very difficult to see how the courts could give effect to the TCA via section 29. I'm not saying they can't, I'm just saying it's not easy to see, it's not clear that they can, and if they can, it's impossible to see how the courts can do so without themselves making difficult policy choices about the detail of what should happen, because without the detail, the law can't take effect. And I just note that this problem, of course, would not arise if EU state aid law remained in place, not only because then we would have a pre-existing body of law which would in many respects comply with the TCA, pending any primary legislation for a different regime, and one could sort of just check that against the TCA, and if necessary, the courts could then make the kind of detailed changes which they do in other contexts when giving effect to treaty obligations under the ECA as it was, or under the Human Rights Act, for example. So that's the difficulty. Now, what does fill the gap, finally, for me, and I'll take this quickly because I'm conscious of time. Well, all we really have apart from that is the BEIS guidance issued by the Department for Business, Energy and Industrial Strategy. That was published, I think, earlier in the year, but the last updated on the 24th of June, and I've given you the link there on the slide. I think the slides will also be distributed. And what it says is, I'm not going to talk about the detail of the guidance because it reflects to some extent what Luke will be talking about, but I just want to think about what its status is. It says as follows: this guidance is designed to help public authorities understand, important that, the UK's international commitments on subsidy control in advance of the development of the UK's own subsidy control regime. Now that's a reference to the bill that James is going to be talking about now. And then it goes on to say that the overview below summarises the key steps public authorities should take. So it's certainly telling public authorities that they must do these things, comply with these different obligations when awarding subsidies after the 1st of January. And then it goes on to tell them that they should also consider those international obligations directly, both under the TCA, the Northern Ireland Protocol, again, that's slightly different in a slightly different category because that does have direct effect, and also by reference to the WTO's agreement on subsidies and countervailing measures. So it's intended that they should comply with it, but what exactly is its legal status? Well, that is very unclear. And I'm sorry, by the way, about this talk, but one of the this talk doesn't reach any clear conclusion, because I think until the courts rule on some of these issues, if they have to, there isn't a clear answer to be given. All that I can show you are the difficulties which arise. So what is the legal status of the guidance? Well, and the obligations to which it refers? Well, in relation to the part relating to Northern Ireland, that's issued under section 48 of the Internal Markets Act, and so the public authorities must have regard to it. And of course, in relation to Northern Ireland, as I've said, there are much more hard-edged legal obligations which arise in any case. But for the rest, it's really not clear what power BEIS or central government generally has to set binding legal obligations via statutory, let alone non-statutory guidance. And indeed, when you look at the guidance in more detail, that's reflected. So a later section of the guidance goes on to say, Note, first of all, that the TCA, it's the first paragraph in that slide, the TCA requires both parties to establish or maintain an independent body with an appropriate role. But of course, the guidance doesn't set up such body. There's no statute for the time being setting up such a body. So this is really just noting that for the time being, the UK hasn't complied with its obligations under the TCA. And it then goes on, the TCA also includes provisions on the roles of domestic courts in reviewing domestic subsidy decisions by way of judicial review. And then perhaps I've underlined the wrong bit here. It's really the next sentence, which is very interesting. Public authorities should be mindful of the possibility that some complainants will challenge subsidy awards by reference to the principles and their effect in domestic law by virtue of the provisions in the European Future Relationship Act. Now that's adverting to the possibility, which I've dealt with in the earlier section of this talk, that someone might try to argue that the TCA can be given effect via section 29 of the FRA, and indeed it might. But it's no more than a might, and it's very unclear whether that's possible or how it would work. And that is, so far as I can see in the guidance, all that it says. Noticeably, although the guidance tells public authorities that they should comply with the obligations in international law, there's no suggestion here that other than via the FRA, that the guidance can be given legal effect. So it's not being said, and I'm not conclusive, but it's not being said the guidance has direct legal effect in its own right. And so we come back to this question of whether the gap is to be filled. The reality is that the status of the obligations, although it sets out a load of obligations, the status of those obligations in UK law is very unclear. Plainly, and for those of you advising public authorities, you'd be very well advised, and certainly central government in particular will be very well advised, because central government may well be more caught by this guidance than others because central government issued the guidance. But public authorities will be well advised to comply with the guidance. And a failure to do so may place certainly the UK in breach of its international obligation, but as I've said, that's not something that can be litigated directly. What about enforcement in the UK? Well, the answer is maybe. The guidance contemplates that the TCA obligations could be enforced by judicial review, but as I've just pointed out, that's arguable. The guidance effectively says it's arguable, but it's far from clear-cut how it would work. Again, the guidance might be something to which public authorities are required to have regard in public law, but at best have regard probably, and possibly not even that for the non-statutory, non-Northern Ireland elements. So there may be an extent to which the guidance could be sort of relied upon as a sort of soft law matter to have regard to, but that's really unclear at best, and the detail of the obligations would also then be unclear. And as I've already said, the guidance itself highlights, or at least draws attention to the fact that the UK is probably in breach of the TCA to a certain extent, pending that primary legislation. And so the position overall is that for the time being, we remain in this great state of uncertainty. I'm going to stop talking now and hand over to the other speakers who are going to tell you about the future that we can be looking forward to. Thanks very much. Luke.
Well, thanks very much, Tim, and good morning to all of you. I'm going to dive straight in to the TCA itself and have a look at what the provisions are that bear on subsidy control within that treaty. As Tim's already mentioned, the TCA is an international treaty. It reflects effectively the Brexit deal as it applies now that the transitional period is over. An unusual quirk of all of this is that the Future Relationship Act, which refers to the TCA, refers to its old article numbers. A final version, which changed only really in respect of getting new article numbers, was published in April of this year. So just a point to be aware of, it's one which caused me some confusion initially, is that what the numbering of articles in the statute and the numbering in the official version don't necessarily tally. Now, the provisions about subsidy control are contained in Title 11 of the TCA. And before we get into subsidy control itself, it's worth bearing in mind what Title 11 overall is doing. And it's concerned essentially with what it itself describes as the level playing field provisions. Essentially, that's going to be state aid, it's going to be competition law, And it's going to be elements which bear on sustainable development, which any of you who've done planning will know is a concept that embraces economic, social, and environmental aspects. The desirability of open competition is set out as a general principle applying to the whole of Title 11, including to the subsidy control provisions in Chapter 3. Similarly, the focus on achieving sustainable development through targeted trade and investment is something which is set out as a general principle applying as well. So the analytical touchstones for the subsidy control regime, in a sense, flow from those two overarching principles. It's worth making that point because it's easy to go straight to the subsidy control provisions themselves and miss that it's embedded within this wider context. What does Chapter 3 do then? Well, Chapter 3 is what gives us the detailed subsidy control provisions. It's no longer called state aid, it's called subsidy control. I don't know why the name changed, but there it is. Subsidy control is the new terminology we need to use in this area. The definition of a subsidy is contained in Article 363, and it has 4 limbs. First of all, it's got to arise from the parties' resources, and it's got various types of contribution which a state can make to a company. It covers things like obvious things like grants and loans. It also covers less obvious things like foregoing revenue or giving a guarantee on a loan, for instance. Any direct or indirect form of subsidy emanating from any branch of the state effectively is going to be at least potentially within the definition. It's got to confer an economic advantage. It's a concept which is familiar to us from state aid. It's got to be specific. So the provision will only bite if it helps some persons or sectors more than others. And like state aid, in order to be a controlled subsidy, it's got to be something which has or might have an effect on UK-EU trade. Now that in the state aid context has been a very, very low hurdle to get over traditionally. Effectively anything which was a subsidy above the de minimis threshold might have had an impact. There is some interesting commentary in the Northern Ireland Protocol, which suggests that the parties, when they're applying this part of the TCA, are going to take a more robust look at whether or not something might actually have an effect. So this limb, which from state aid has been virtually negligible, it's so easy to get over, I expect is going to be much more significant in the context of subsidy control. It's worth briefly touching on when a tax can be a subsidy, or a tax provision, I should say, can be a subsidy. Now, if a person gets more advantageous treatment than others who are within the ordinary tax regime, so if you create a particular tax carve-out directed at particular persons or sectors, that's the sort of thing which can be a subsidy. Article 363 sub 2 tells us that. But there are two exceptions which are worth bearing in mind, or I should say 2 qualifications. The first is that if your differential treatment flows from the general design of the tax, it flows from principles inherent in the tax, as it were, then that's not specific for the purposes of the 4-part definition of subsidy. So if, for instance, you have hardship exemptions from paying a tax, or you have particular environmental provisions which favour environmentally friendly activities over others, those sort of things which are general principles are not going to be qualifying as specific here. And finally, you can have special purpose levies if they're targeted at non-economic public policies, environmental protection being the obvious one, bearing in mind the environmental element to sustainable development here, as long as the tax is non-discriminatory itself. So this can't effectively be a cover for a subsidy via the tax system. It's got to be objectively non-discriminatory. But as long as it is, then special purpose levies for non-economic purposes are fine. Before we look at what the general provisions are, it's worth touching on what the exceptions are to the subsidy control regime. Particularly in the case of local government and of small businesses, even larger businesses actually, the most interesting area, the area of most immediate pressing concern, is usually the de minimis threshold. As we all know, it's been €200,000 under the state aid regime. That's gone up quite considerably now. What the TCA says is that the de minimis threshold is 325,000 special drawing rights over 3 fiscal years. Now, a special drawing right is a form of reserve asset which the IMF controls. It's based on a basket of the values of 5 currencies, of which the euro and pound sterling are 2. The others are Chinese currency, Japanese yen, US dollar. The way it works isn't important. What's important for our purposes is how it equates to currencies which we all know. I've put there, as of yesterday, 325 SDR was about £336,000, or just under €400,000. So we've had effectively a doubling of the de minimis threshold under the TCA. Another exception, which is quite pertinent at the moment, is for temporary measures targeted at national or global economic emergencies. It's clear from base guidance, which is around business rates at the moment, that the government regards the European Commission's temporary framework for coronavirus relief as being covered by this exception, completely unsurprisingly. And what that means is that when you have things like government grants to businesses, which are subject to various caps depending on the nature of the business and the trouble it's in, those are done still by reference to what the European Commission is doing, and that is being regarded, understandably, as being caught by the TCA as well. Final exception relates to public interest actors, as the term in the TCA. This effectively is where the government uses a private body to deliver a public function. Something like private prisons is an obvious example. In those circumstances, subsidies are acceptable as effectively funding the public interest bit of what the private body is doing. What you can't do, though, is give the funds to the private body in a way which the private body can use to cross-subsidise its non-public interest activities. It's also worth bearing in mind that the TCA says in terms that this exemption only applies where the function's been assigned transparently and in advance. In other words, you've got to properly procure it before you can rely on the exemption in Article 365 as one of these bodies. The main principles then, Article 366, this is the real meat of the TCA's subsidy control provisions. And this sets up the general framework within which the UK has to legislate when it creates its own subsidy control regime. It sets up 6 principles. These fall broadly into 2 categories. There are principles of necessity and principles of proportionality. Now, oddly, the need for the subsidy to be necessary and proportionate is the second principle. The rest of them seem to me to be encompassed within those 2 concepts. So going through them quickly, you've got to have an identified public policy objective which is targeted at an identified market failure. That's your objective touchstone for whether or not a subsidy is permissible. And it's got to be necessary and proportionate. Specifically, it's got to be necessary to change the economic actor's behaviour in a way which furthers the objective which justifies the subsidy. In other words, if you don't think that the actor's going to respond, then you can't give the subsidy. You can't subsidise costs that will be borne in any event. It's effectively a but-for causation type test. But for the subsidy, would this thing happen? If the answer is yes, you can't give the subsidy. Again, seems to me a sub-limb of necessity, really, but it's there on the face of the TCA. You can't give a subsidy if you could achieve the objective via a less distortive method than by a subsidy. Again, that seems to me to be a subset of proportionality, really. But again, it was important enough as a subcategory that it's been included in Article 366. And finally, you've got a balancing exercise. You've got to balance the positive contribution to achieving the objective on the one hand against the negative of market distortion on the other, because any subsidy is always a market distortion in this context. So that balancing exercise is the final step that has to be gone through. So that's the framework within which the bill is going to have to fit if it's going to comply with our international objectives. I'm not going to say anything about the bill, as James is going to come on to that, but that's the framework. Article 367 gives us a whole series of subsidies which are expressly prohibited or are subject to particular limitations and controls. Prohibited subsidies, I've given a number of those here. For anything that isn't a bank or an insurance company, an unlimited guarantee is always going to be prohibited. A restructuring contribution where there isn't a credible restructuring plan is always going to be prohibited. And except in exceptional circumstances, you can't give a subsidy to restructure a company unless it meets the public interest either of preventing social hardship or severe market disruption. So those are your public interest limbs for funding restructuring. Slightly different for banks and insurance companies. If you've got a long-term viability plan for the restructuring and it's credible, then you could give a subsidy to one of these institutions. The only other way you can give a subsidy to a bank or something like it is to allow an orderly market exit. In other words, if the choice is between giving a subsidy or having a collapse, which is going to cause a run or something like that, then you can give the subsidy to allow the liquidation to be controlled rather than uncontrolled. There are a number of other prohibited subsidies. Won't go through them all in detail. They're there on the slide. Certain export subsidies are not allowed. You can't have an import subsidy, which would cause domestic goods to be favoured over imported ones. And you can't give a subsidy which has the effect of relieving a person from its liabilities for environmental harm. So that's an express recognition of the environmental objectives of the TCA being pulled into the subsidy control regime. And finally, airlines are prohibited from receiving subsidies in most cases. Transparency is an area which has been touched on. In effect, if a subsidy is given, it's got to be published online with a series of details given about it within 6 months of its grant, unless it's a tax measure, in which case it's got to be within 12 months. There is also within Article 368 a sort of freedom of information type provision, which can in certain circumstances require information about subsidies to be given to a person who asks for it with a view to commencing litigation about the lawfulness of the subsidy. The information which is provided has to be targeted at how the subsidy fits within the Article 366 framework that I went through a moment ago. Finally then, let's have a look at some of the oversight provisions before we move on to what the bill says. Article 370 sets up inter-party consultation requirements and structures, so that if the EU thinks that the UK is doing something problematic or vice versa, the parties can go through the steps and consult on the subsidy and try to sort it out in that way. Article 371 sets up a requirement for independent bodies to deal with subsidy control. And as Tim's mentioned, the UK is already in breach of this requirement because there's no such body as things stand. Article 372 creates the justiciability of subsidy control. This requires the parties to give access to the courts, effectively, for any interested person and indeed for the other party to the treaty, so that the EU itself can be a party to a judicial review of a subsidy issue in the UK. Worth mentioning as a sub-comment there, though, Article 372 expressly provides that the UK doesn't have to expand any of its domestic law or its domestic public law to accommodate this kind of challenge. So we can apply the general principles of judicial review here. There's no sort of pulling in of any kind of fact-based assessment or more detailed proportionality assessment rather than irrationality. So UK's domestic JR principles are preserved by the TCA. And finally, Articles 373, 374 deal with recovery and remediation in the event that a subsidy is given which turns out to be unlawful, or where there's a challenge to it from the other party. So I hope that's been interesting and helpful. It's a quick whiz through the provisions of the TCA. We could spend a very long time talking about it, but those are what I hope are the key points. And I'm going to hand you over to James, who's going to talk about the bill and how all this is being dealt with domestically. Thanks, James.
Great. Thank you very much, Luke, for setting the context for the Subsidy Control Bill. As Tim said at the outset of this seminar, it's particularly timely because the Subsidy Control Bill was only published on Wednesday. And so what I propose to do for the purposes of this presentation in the next 15 minutes or so is to give you a whistle-stop tour of the new provisions of the Subsidy Control Bill and setting out broadly its structure and with particular emphasis on how the enforcement mechanisms will work. I won't have time to analyse in any real detail how closely aligned to the provisions of the TCA the bill is, because that is in itself that is no small task and would take us well beyond the next 15 minutes. But as I say, I'm just going to give you an overview of how the new regime or how the government proposes the new regime will work. So just looking at the structure of the bill, one of the first things that struck me looking at the bill, and which is particularly welcome to those who've practiced in EU state aid for the last few years, is the relative simplicity of its structure. So what the bill is divided into 5 parts, which broadly follow a logical order. We have part 1, which tells us what is a subsidy. Then we have part 2 of the bill sets out the main and substantive obligations on public bodies in terms of subsidy control, and that's entitled the subsidy control requirements. Part 3 sets out the exemptions to those requirements. Part 4 makes provision about referrals to the Competition and Markets Authority. And then part 5 sets out provisions in relation to enforcement, and in particular, the role of the Competition Appeals Tribunal, the CAT. I'm not going to comment at this stage too much on that latter structure until we get to those particular parts. But what I thought I would do is just set the context to the discussion of the provisions by looking at what the government actually said when it commenced the consultation on the subsidy control regime back in February. So this is what the government said in terms of what it wanted out of the new subsidy control system in the UK. It said it wanted a system that strikes the right balance between allowing the benefits that can be derived from subsidies whilst limiting the most harmful impacts. And the objectives were, as set out in the slide, facilitating interventions to deliver on the UK's strategic interest, maintaining a competitive and dynamic market economy, protecting the UK internal market, acting as a responsible trade partner. Now, just pausing there, you'll notice protection of the internal market is mentioned there, and that is, of course, that is going to be one of the new features of this regime. For the first time, in essence, there's going to be domestic law governing the way in which the UK internal market and subsidies from individual, particularly local authorities, should be governed so as not to distort the UK internal market between the 4 nations. Now, acting as a responsible partner is, I'd like to assume, means also complying with international law. I'm not going to dwell too much on any of the points about interpretation, because Tim's dealt with that already. But there are some provisions touching on some of the legislation that Tim's already mentioned in relation to interpretation of how the bill or the act should be interpreted. So moving on to the key definition of subsidy. Now that's set out in section or clause 2 of the bill. I'm not going to dwell on this too long because, of course, it does broadly chime with the provisions of the Trade and Cooperation Agreement that Luke's already mentioned, and isn't, for those familiar with EU state aid law, broadly, there's no surprises in this definition, save only, of course, that there is reference under subsection 1, paragraph D2, at the bottom there, to financial assistance which is capable of having effect on trade between the UK and the country outside the United Kingdom, but also, of course, competition or investment within the UK. And that goes back to my point earlier about the internal protection of the internal market. In terms of financial assistance, I've just flagged up what the bill says about the definition of financial assistance, just so you have it to hand. That's an inclusive definition. Again, no particular surprises there, because that broadly chives with what's set out in the TCA. It is, of course, an inclusive definition, not an exclusive definition. And I'll come on at the end as to where the bill still doesn't really address some of the concerns of the raised in the consultation about the need for detailed clarity, preferably through statutory guidance, as to what some of these concepts actually mean. So although it tells you what financial assistance it may include, we see that in clause 2, the Act doesn't provide any further clarity on this or guidance, and in fact worse still, leaves it to the Secretary of State to publish guidance setting out the meaning of financial assistance. And I'll come on and just touch on that at the end as to why I think that may create a few problems. Just going to the meat of the bill now, the 6 main duties, which, and this part of the Act's headed the subsidy control requirements. For ease of reference, and just as a sort of taster of what the bill entails, I've grouped the duties under the subsidy control requirements into 6 main categories. The fundamental duty, and the most important one, is the duty to consider on a public authority, to consider the subsidy control principles. We'll come on to what those are, because those are set out in a schedule at the end. There's also a corresponding duty under clause 13 to consider the energy environment principles, and again those are set out in the schedule at the end. Now, alongside those duties to consider and not to grant subsidies unless the public authority is of the view that a subsidy is consistent with those principles, there are also a whole series of general prohibitions set out in Chapter 2 of this part, prohibiting the giving of certain subsidies and imposing other requirements in relation to some of them. I'm not going to have a chance to go through all of those, but they include things like unlimited guarantees, subsidies that are contingent upon export performance, a subsidy that's contingent upon the use of domestic goods over imported goods. These are some of the points that Luke's already flagged up, so I'm not going to dwell on them too long. They number, the clauses go up to clause 28 in terms of those prohibitions. And as I say, they broadly mirror and in fact closely aligned, as you would expect, with those that are set out in the TCA. Just touching on services of public economic interest. The services of public economic interest, and that the meaning of that clearly derives from the TCA. That there are transparency requirements in relation to the giving of those, and those are set out in 29. And there's a duty that they should be given in a transparent manner. And that really, in essence, means that if those subsidies are being given under this provision to a SPEI enterprise, then that has to be through a written contract, and it has to include certain specified information. And so that's an important provision in relation to those particular services. Now, the key, in terms of enforcement, the key provision under the Act, and the way the whole Act or the whole bill works, is the prohibition under a prohibition if there has been a mandatory referral to the Competition and Markets Authority, and that prohibition remains in force until the CMA has reported. Now, what triggers that mandatory referral is whether a subsidy is in inverted commas of particular interest, and that is going to be defined in regulations set out by the Secretary of State. There's no further detail of that, but that's the key. That's the key prohibition, and that's the key essentially an enforcement mechanism, because the CMA therefore effectively has a right to report on whether both there has been financial assistance given and whether the subsidy control principles I've referred to above have been complied with. Now, and then there's one final obligation which important to note, is that there's a duty to enter subsidies in a central subsidy database. So essentially for the first time, anyone will be able to see what subsidies have been given by both local and central authorities in the UK. And that's an important development. And given some of the interest that we've seen in terms of public procurement behaviour, this might be of particular interest to organisations such as, for example, the Good Law Project, looking at how public money has been spent. The subsidy control principles now, I'm looking at those in a bit more detail. I've set those out, the key principles on this slide. I'm not going to read them all, because broadly they align with the TCA principles that Luke's already referred to. Just to give you a flavour of what the energy environment principles say, there are a number of principles, but I've just set out paragraph A that says subsidies in relation to energy environment should be aimed at and incentivise the beneficiary in delivering a secure, affordable and sustainable energy system and a well-functioning competitive energy market, or increasing the level of environmental protection compared to the level that would be achieved in the absence of this subsidy. So those are important new substantive principles that have to be complied with when granting subsidies under the court by the bill. Now, moving on to part 3 of the bill, this is where exemptions are set out, and this, of course, is an area of particular interest to local authorities to try and make sure that any subsidies fall below the thresholds. The minimal financial assistance threshold is proposed to be 315,000 over the last 3 financial years, which I think broadly or should correspond with the reference to special drawing rights in the TCA. That exemption doesn't apply at all if the subsidy contravenes export performance or use of domestic goods prohibitions. So those are the fundamental no-nos in terms of subsidy control, which derives from the WTO obligations and indeed the TCA itself. And then there are some requirements over how, when granting minimal financial assistance, that should be notified to the beneficiary of that assistance. Higher threshold for service of public economic interest assistance, so SPEI assistance, and that's £725,000 over the last 3 financial years. And there are provisions that address where you have a mix of minimal and SPI assistance and what the total amount should be. And then there are a whole other series of exemptions which you might expect for natural disasters other exceptional occurrences, monetary policy by the central bank, by the Bank of England, for example, financial stability directions, etc., etc. Now, moving on to the next slide, just having a look at what the role of the CMA will be in a bit more detail. As I said, there's a duty to refer a subsidy to be considered by the CMA before giving a subsidy of particular interest. That will be defined in secondary legislation. What happens is the CMA will respond within 5 days of that request and then has to confirm whether the request is valid or not. And then significantly, it's only got 30 working days to publish its report. Now, for those of you familiar with the EU state aid regime, that is a very welcome deadline in terms of waiting, in terms of trying to get sign-off from the regulator before granting subsidy. As we all know, there's been awful problems with the Commission sitting on notifications under Article 108 of the treaty to the Commission. And I think this provision is there to try and instill some discipline and rigour into the process and force the CMA to publish its report in good time and not hold up projects which are awaiting that sign-off. However, the Secretary of State does have discretion to extend that deadline. And I can see that the CMA will, unless resourced properly, will have to write to the Secretary of State and will probably have to take advantage of that discretionary extension power because otherwise it's going, I suspect it will be inundated. There's a cooling off period of only 5 days post-publication before the subsidy award can be granted. There is, the subsidy can be granted. There is a provision for voluntary referrals to the CMA. So even if an authority thinks that what it's granting may be caught by the provisions of the bill, then it can refer those to the CMA and await a result before proceeding. The Secretary of State does have a power to step in and make a referral to the CMA up to 20 days after it becomes aware of the subsidy because it's been entered into the subsidy database. Now, what happens next in terms of enforcement? Well, first of all, one of the gaps in the Act, one of the things that the Act doesn't address is what does an authority do when it receives the CMA report. I think there's nothing that specifies what the authority should do. So in theory, an authority can look at the report, it seems to me, and then proceed to grant the subsidy, regardless of what the report says. At least that's in theory. Of course, as a matter of public law, it would have to take into account what the CMA says. So in reality, it seems to me there is a duty to look at what the CMA report says before taking any further action. But that, somewhat bizarrely, that's not actually specified in the Act. In terms of enforcement, an aggrieved interested party can appeal to the CAT for a review of the subsidy decision, and that will be on judicial review principles. There are tight time limits, so for any challenge, essentially 1 month after what's known as the transparency date, which is the entry into the central subsidy database, or when the interested party knew or ought to have known of the decision, and that's a familiar phrase that's arisen in plenty of EU legislation, for example. So that's actually constructive notice of the decision. For those awards that have been referred after the award to the CMA, the deadline is for any challenges 1 month after the CMA report is received. Now, the Competition Appeals Tribunal's powers in terms of relief are the same as the High Court's powers in respect of judicial review, plus recovery powers under Clause 74, which confers the right of recovery on a public authority, and requires the authority to exercise that right. And there's I won't dwell on this, but Clause 77 deals with misuse of subsidies and how an authority can call that back. Now that's very much a whistle-stop tour of the bill. There's clearly a lot more detail in there, particularly in terms of the subsidy control principles and the schedules. I just want to flag up my final slide, just just as sort of concluding points, some areas of likely controversy, criticism and uncertainty. Broadly, in my view, and as consistent with what was expected as a result of the white paper, it does seem that the bill will be broadly welcomed as a key improvement from the state aid regime, particularly by local authorities, in terms of the removal of the particularly rigid prior notification requirements of the Commission under Article 108. And I think that will be broadly welcomed across the board, both by central and local government. And as I said before, the set timescales for the CMA reports will be a significant improvement from the prior EU regime. However, some of the difficulties and some of the issues that are likely to crop up through the bill's passage through Parliament, I've set out here that I've been able to spot in the day or so that I've reviewed this. The question of what a subsidy of particular interest is critical, because that clearly includes high impact subsidies and high value subsidies. But that's to be determined by the Secretary through Secretary legislations. We just don't know what the thresholds are going to be for referral to the CMA. There is still very little definition on what some of the terminology that has caused such problems in the application of the EU state aid regime has been. So, insufficient definition of effects on trade, for example, within the definition of subsidy. And I'm not going to dwell on this, but of course there will be a tendency for cautious public bodies to apply the state aid, the EU state aid case law authorities by default in the absence of that clarity in this particular, under this regime. There's considerable guidance that's still required to assist in terms of the application, if not the meaning, of the subsidy control principles. For example, how do you balance a subsidies policy objective and its effects on domestic competition and international trade and investment? And all that is going to have to come out in guidance. And then just finally, on the point of guidance, I can already see that there will be some difficulty over course 79 of the bill, which I haven't put up on the screen, which talks about the Secretary of State issuing guidance about the practical application of the principles, including the energy environment principles, subsidy control principles, etc. All that sounds reasonably sensible. But then it also says that guidance may in particular deal with the determination of whether financial assistance constitutes a subsidy for the purpose of the Act. And then interestingly, the meaning or effect of the subsidy control principles, and then the meaning or effect of the energy environment principles. And I can see an immediate problem there, that guidance isn't really there to tell you what something means. It's there to assist the decision maker in how to apply, for example, primary legislation. But if I can see that there is a bit of a muddle there in clause 79, which no doubt will be discussed as the bill progresses through various stages of the Commons and the Lords over the next few months. I'm conscious of time. That's all I was going to say for now. It's 10 past 12, so we're slightly overrun. Yeah, I'm probably best to hand over to Tim now and see if there's any questions.
Thanks very much, James, and thank you, Luke. So we have, as James has just said, run rather over time. Actually, it may well be my fault. We've come into 10 past 12 and we're due to finish at 12. In fact, I can see that we've got one question in the Q&A, and Luke has I think it relates to Luke's talk, and he's very kindly warranted to me that he thinks he can deal with that hopefully relatively quickly. So what we'll try and do is, because there's just the one question, we'll take that question and then perhaps call it a day. If you want to try and ask a question in the next few moments, please do, although we'll have to see how we go in terms of time, because Luke, among others, has to get away. So the question is, well, shall I hand it over to you, Luke, and you can deal with it, deal with the question and then explain your thinking?
Absolutely fine, Tim. Absolutely fine. So for those of you who can't see the Q&A, the question relates to the new de minimis threshold. The question is this: whether the clock is reset by the new threshold. So recipients can now receive, let's say, £315,000, that's the bill amount, on top of anything already received under the state aid de minimis threshold, or whether the new threshold is effectively a top up to that. Now, the TCA itself doesn't deal with this point, but it seems to me as a matter of principle, and this is a principle which also is reflected in the Bayes guidance on this issue, that there's intended to be continuity between the two regimes in this respect. So if you've had £200,000 of state aid, i.e. up to but not exceeding the de minimis threshold in 2020, the effect of the change of regime is that you can get an extra £115,000 in 2021. So you can top up that 200,000 to the new TCA threshold. What you can't do is get an extra 315,000 in 2021 and simply ignore the 200,000 you already had. So the expectation of the government, and it seems to me the intention underlying the TCA, is for there to be continuity between the two regimes in that way. It's worth bearing in mind in that regard, of course, that if something was state aid for the or within the definition of potential state aid, I should say, for the purposes of EU state aid law, almost by definition, it's going to be a subsidy for the purposes of the TCA as well. So that you would have received the subsidy previously within the previous 3 fiscal years if you'd taken 200,000 up to the state aid limit. So in short, it's a top up, not a reset. Hope that answers the question. Thanks very much, Tim.
Thank you very much, Luke, and a very clear answer. I think the person who answered the question has also said so. We've gone way over time, so we'll call it a day there, I think. Thank you so much for attending. We hope you found it useful and informative. Thank you to our speakers, and we look forward to seeing you again in the near future. Thanks very much, everyone.